Hey everyone, today we're going to go into more detail about confidentiality and informed consent. Um, Confidentiality and informed consent have not always been a thing. It's been in more recent times that we've focused more on keeping patient information confidential while trying to meet all of their needs. The doctrine of informed consent was created because there was such an increase in the demand for patient information from the patients themselves in order to make a decision on getting or not getting treatment, but also a demand from insurance companies for payment. Okay. So, when dealing with the issue of confidentiality of patient specific health information, the focus is the relationship between the patient and the doctor. So, the patient gives the doctor information that's going to help them diagnose and treat them, and the patient is able to give them this information without being scared that the doctor is going to tell anyone else their private information. This obligation of confidentiality is part of the Hippocratic oath that doctors take. Okay. And now, because of the advances in technology, the fact that insurance companies play such a big role in healthcare, and just the increase in the amount of available information, there's now this complex web of legal protections around confidentiality. These legal protections are based on the patient's right to privacy. So, the right to be left alone and to control their personal information. And you can find these legal protections in these sources here: constitutional provisions, statutory provisions, common law, and international provisions. Okay, so we're going to go into each of these. All right, while the right to privacy is not specifically listed in the U.S. Constitution, the U.S. Supreme Court has said that a fundamental right to privacy does exist. In the case listed here, Whalen versus Roe, the state of New York made a law that allowed them to make a database listing out the patient's names, addresses, ages, and also the pharmacy and physician that prescribed certain like dangerous drugs. Some of the patients and actually two of the doctors challenged this law because it did violate the patient's right to privacy. But the Supreme Court decided that the public's need for information, the state trying to deter this drug abuse, outweighed the individual patient's right to privacy. Okay. Now, some states do have stuff like specific to patient privacy in their constitutions, but not all of them do. The right to privacy is recognized by both federal and state legislatures. So, on the federal level, the law focuses more on record keeping. We have the Freedom of Information Act, or FOIA, which gives people the chance to request and access governmental records. And then the Privacy Act of 1974, which says certain information is confidential and cannot be disclosed unless there's written consent by the individual. So, how does this impact healthcare? The Social Security Administration and the Department of Health and Human Services, which are both executive branch agencies, can release information for the purpose of research and statistical studies, but they have to follow the statutory provisions of removing any patient identifying data. Okay. Now, on the state level, the confidentiality protections falls into there's three categories. Open record statuses apply to records held by a state agency, and it's very similar to FOIA. They have to disclose them unless there's an exemption. The physician-patient privilege applies to the introduction of evidence at trial. It's used to prevent forced disclosure or the doctor having to testify about private information of the patients. And then privacy statutes is kind of like the Privacy Act. Information is kept confidential unless the patient authorizes it. common law basis gives someone the right to file a lawsuit for damages. It, that someone someone inappropriately obtains, discloses, or uses patient-specific health information. So examples of this type of lawsuit would be invasion of privacy claims, defamation, and breach of contract. Okay. On an international scale, there have been a lot of upgrades to data protection laws in the European Union, the biggest being the General Data Protection Regulation, the GDPR. So this expands the definition of what would be considered personal data that has to be protected. This would be any information that could identify someone. Any physical, physiological, genetic, mental, economic, cultural, and social identity factors. Okay, this would even apply to someone if someone from the EU saw a doctor here in the US, which I think is pretty cool. Okay, a lot of people think the terms confidentiality and privacy are the same thing, but they do have separate definitions. Privacy is a right that belongs to the patient, okay? And confidentiality is a duty that belongs to the provider, the doctor or the nurse or whatever, to not spread the patient's information, okay? So think privacy, patient, PP to remember the difference. And then confidentiality is the doctor's duty, okay? The HIPAA privacy rule defines confidential health information as protected health information, or PHI, and would include anything that can identify the patient. Okay, so their name, address, date of birth, date of death, any admission dates, their phone numbers or email addresses, social security numbers, health record, insurance number, pictures, or any other identifiers. Okay. So unless the patient authorizes you to release it, you have to de-identify the information before you do so. Any healthcare providers, doctors, nurses, health information professionals, we all have an ethical obligation to protect patients' PHI, which is becoming harder because the demand for patient-specific information has gone up. So in response to this increase in demand, the HIPAA privacy rule requires healthcare providers to issue a notice of privacy practice to every patient. You've probably gotten one before if you've ever gone to a doctor's office or a hospital. It informs the patients of their rights under HIPAA. So it talks about disclosure, safeguards, any duties the doctor has about PHI. So, they've asked you to sign the HIPAA disclosure, and then they'll give you a little form with listing all that out. And you probably throw it in the trash. Okay, the nationwide privacy and security framework for electronic exchange of individually identifiable health information. Okay. This was issued by DHHS to address privacy and security challenges related to electronic health information exchanges. So it's based on the HIPAA privacy rule, and the principles are individual access and individual choice, correction, openness and transparency, collection, use, and disclosure limitations, data quality and integrity principles, and safeguards and accountability. Okay. I apologize in advance that this chapter has a lot of little things listed like that. Okay, HIPAA requirements, the implementation of the electronic health record and the expansion of electronic health information exchange efforts have led to health information professionals expanding their responsibilities. Okay, so increasing the need for confidentiality and privacy in more recent years. And really, this is only going to continue to expand, okay? Especially with AI and all the things that are happening now. In the context of research, the duty of confidentiality is shared between the research team and the institutional review board, which is like the supervising body in institutions that do research involving humans. Okay, so these two groups have to make sure the provisions of the common rule are met to protect the subject's privacy and maintain their confidentiality the whole time of the study and even after the study's finished. The concern focuses on the subject's ability to access their information and also their body in the case of like specimens being collected from them. Okay. For HIV information, some states have special protections on not only the patient's identity, but also their test results. The patient's test results can only be given to the patient or their authorized representative, or their doctor or public health authority. Okay. Like we've talked about before, the release form has to have a special part specifically stating HIV related information can be disclosed, that the patient has to check off. And of course, if there is an unauthorized disclosure, the patient can sue. There are exceptions that can allow disclosure, but that's really related to public safety. Okay. Most professional associations have guidelines that help the doctor decide on the course of action, or to establish standard of care. The American Medical Association, or AMA, has a set of ethical guidelines, and it says that even after a patient dies, their HIV information still has to remain confidential, and when that information can be included in an autopsy. It has like specifically what instances would allow it. Okay, so the issue of consent originally became a thing in the early 1900s, and it was based on the theory of battery, which, if you know, I know everyone remembers, that's the unauthorized touching of someone else. So initially, if a doctor didn't obtain the patient's consent before treating or touching them, they were liable for battery. So as time went on, the focus of these lawsuits kind of changed from did the patient consent to the treatment to did the patient truly understand the nature and effects of this treatment? Did they have enough information to make an informed decision? Okay. So with this new question, the basis of these lawsuits changed from the ethical theory of battery to the ethical concept of autonomy, which again, I know you all remember this, but autonomy requires the doctor to tell the patient any and everything that they would need to know to make an informed decision about their treatment. Okay, so the patient has to act voluntarily, meaning decide on their own the extent of the care that they want to receive. Okay. Over time in these lawsuits, negligence principles started being used, and they developed this separate legal theory, the doctrine of informed consent. So this doctrine places the duty on the doctor to not only obtain the consent for treatment, but also to explain to the patient, you know, the nature of the procedure, what risks are involved, if there's any alternatives available, and what the expected results should be. This whole process has to be documented in the health record, or the doctor can be held liable. Okay. And this process meaning the doctor explaining all this information to the patient. That all has to be documented. Okay. The last topic we're going to talk about is the scope of informed consent doctrine, which can be measured in several ways. So, one, who can consent to treatment? Two, how much information must the healthcare provider disclose? And three, what situations require conformed consent? So, who can consent to treatment? If the patient is a competent adult, they can consent. If they are incompetent, an authorized person can make the decision, and this is called substituted consent. Some underage marriages, armed service membership, or complete self-sufficiency. We're not really going to go into that, so don't worry about that bullet. All right. For a patient that is a minor under the age of 18, then their parent or legal guardian can give this substituted consent. If they are emancipated, they would be considered competent and can give that consent themselves. This would be for things like getting married, childbirth, entering the military. The exception for this is if a minor is pregnant or has an STD or is dealing with substance abuse or mental health issues. They can give consent even if they aren't emancipated. Okay. For legally incompetent patients, whether they have always been incompetent or were once competent, but because of an illness or accident have become incompetent, the question is if someone acting on the patient's behalf has the right to refuse treatment if the result would be them dying. And this really wasn't talked about until this case here, Cruzan versus Missouri Department of Health. The patient, Nancy, got into a car accident and was in a vegetative state. Her family eventually wanted to take her off life support, but the hospital refused because she hadn't made an advance directive before the accident. And the Missouri state law required basically in writing that she would have wanted to be taken off of life support. So in this case, the U.S. Supreme Court ruled in favor of the state, seeing that this requirement didn't violate her constitutional rights. So this case raised a lot of concerns about end-of-life care and eventually led to the passage of the Patient Self-Determination Act, or PSDA, which the goal of it is to ensure that a patient's right to self-determination, specifically in healthcare decisions, be communicated and protected. Any healthcare providers that are Medicare or Medicaid certified are required to tell their patients about any state laws regarding advance directives for accepting or refusing services. Okay. And I know we talked about advance directives already. I think that was last chapter. But this is a good thing for you to tell, especially like your elderly relatives. Kind of like the case study asked about, what options would you give your relative? These are things that they should have in place. And even if you bring up the idea just to have them thinking about these things, kind of plant the seed so that they can maybe eventually make an advance directive. That takes the burden off of you as the family, right? Anyways, a refresher on advance directives. So this is the written document that the patient makes before they become incompetent that states exactly what kind of care they want. Whereas a living will lists out any medical care wishes that they have, while a durable power of attorney is like specifically naming someone else to make their healthcare decisions for them in case they do become incompetent. So they kind of all go together, but they're just, a little bit different. All right. The Patient Self-Determination Act also requires the doctors to make sure that it says in their health record whether or not they have an advance directive, and if so, what type. Also, to avoid any discrimination against patients on the basis of whether or not they have an advance directive, okay? And then lastly, an obligation on the doctor to educate and communicate with their patients about the importance of having an advance directive. Every state has the authority to define the legal rights around advance directives. The PSDA doesn't alter these rights under state law, right? Okay. All right, so to recap, the state statutes regarding advance directives talk about the substantive legal rights, meaning the actual rights that they're entitled to, whereas the federal laws address the procedures by how those rights can be exercised. Okay. The Department of Health and Human Services expects you to comply with PSDA, and the Joint Commission and DNV Healthcare have also issued standards that address advance directives. And then like your facility would also probably have a policy and procedure in place that talks about this as well. Okay, now what happens in an emergency situation where the patient can't consent to treatment, but they need it, or they could die or be seriously harmed? And there's not, they don't have a loved one there to consent for them. State legislatures have made laws to protect these doctors. I'm sure hopefully some of you remember the Good Samaritan laws that protects doctors or rescuers or private citizens from this risk of liability. Okay. Sufficient disclosure is actually a matter of state law. This includes nature of the proposed procedure and treatment, risks, benefits, and then any available alternatives. Okay, so these are the things that have to be disclosed. All right, and that's considered sufficient disclosure. Disclosure is measured under the law from two different perspectives. So the healthcare providers and then the patients. So from the healthcare provider's perspective, the professional disclosure standard measures what a reasonable doctor under the same circumstances would disclose. So for this, expert testimony would be required to figure that out. Another doctor in the same field, what would they do? The second approach, called the reasonable patient standard, measures what material information is necessary for an average reasonable patient to make a decision to consent to or forgo treatment. So because it's from the patient's perspective, this one you do not need expert testimony. All right, so unless there's an emergency situation, any treatment given requires the patient's consent. Or tacit consent happens when a patient voluntarily agrees to have a procedure, right? That is very low risk. So things like getting their temperature taken, their pulse or taken, or having their blood drawn, okay? That involves tacit consent. Express consent or informed consent is required in cases where diagnostic or therapeutic procedures will be performed. For these, the risk of harm may or may not be readily apparent to the patient, but it's generally considered to be more than slight. So examples of this would be like invasive surgery, radiological therapy, or procedures that can change the body structure. Express consent is also required in the context of experiments and research. Okay, there's a lot of strict requirements about that. All right, and I think, yes, that is all I have for y'all today. So good luck this week, and I'll see y'all next time.